Hi, everybody. I'm Aaron Kramer, President and CEO of BSR. We are, for those of you who don't know us, we're a global business network and consultancy with 300 plus member companies globally. We work with to advance just and sustainable business. It is great to be with everyone today. Thank you for joining for the 20th episode in our conversation series, ESG influencers. ESG, a term we're not being used as much anymore, but I think you know what we mean. You can call it sustainable business, responsible business, leading transformative change. That is the fundamental principle. We're honored to have another very timely and interesting guest with us today, Michael Gerrard, who is professor and founder and faculty director of the Sabin Center for Climate Change Law at Columbia University. I'll tell you a little bit about Michael. Michael is an advocate, litigator, professor, and scholar who has pioneered legal tools and strategies for addressing climate change. He teaches courses on environmental law, climate change law, and energy regulation, and chaired the Earth Institute at Columbia from 2015 to 18. He also holds a joint appointment with the Columbia Climate School. Before joining Columbia 2009, Michael practiced law in New York for 3 decades, trying numerous cases and arguing many appeals in federal and state courts. He's handled environmental aspects of transactions and development projects and provided regulatory compliance advice to various clients. If that weren't enough, and it's quite a lot, Michael is also a prolific author. He has written or edited 14 books, including Global Climate Change and U.S. Law and Legal Pathways to Deep Decarbonization in the United States. His Environmental Law Practice Guide and Brownfield's Law and Practice received the American Association of American Publishers Best Law Book of the Year award. And there's more. He has chaired the ABA's section of Environment, Energy, and Resources and the New York City Bar Association's Executive Committee. He has taught at Yale, the Université de Paris, #1, Panthéon-Sorbonne, and also the University of Malta, and has lectured globally on environmental law. Michael, I'm delighted you could be with us today.
Thank you for
Um,
having me.
it is a pleasure. And BSR has been proud to partner with Morrison Foerster, a great law firm with whom we work on a whole range of things. And we've been partnering on this series. And today we'll have the benefit of Bill Tarantino leading the questions. Drawing on his wide experience in environmental health, Bill focuses his practice at Morrison Foerster on environmental and consumer protection law, with an emphasis on climate-related goals and claims, hazardous substances, mass torts, and consumer product safety. Bill started his career at the US EPA at the Office of Regional Counsel in San Francisco, and he currently leads the firm's environmental practice. In that capacity, Bill routinely advises clients in connection with their carbon reduction and climate-related goals and claims, including carbon neutral and net zero carbon commitments, something I'm sure we'll be talking about today, and helps clients substantiate their claims and avoid greenwashing claims. Pardon me. He defends clients in environmental and consumer class action litigation in courts throughout the United States and is highly regarded, pardon me, for his ability to coordinate technical, legal, and communications teams to counsel clients through crises. So today, in an environment that is a bit volatile and very changeable, we will focus on the rise of climate litigation and bring to bear the very broad knowledge and expertise from both Michael and Bill. So, Bill, take it away.
Great. Thank you very much, Aaron. And Professor Gerrard, we're delighted to have you with us, given your wealth of knowledge and expertise. And as a practitioner in this space, and for those of you that are watching, if you're not familiar with the Sabin Center's climate litigation database, I encourage you to become familiar with it. It's the authoritative resource for all of climate change litigation, regulation, both in the US and globally. And we'll talk a little bit about some of the work that the Sabin Center has done. But first, I want to just kind of set the scene and get some of background from Michael's practice. Um, could you tell us a little bit about your journey to become one of the leading voices in climate and environmental law?
I entered law school in 1975 to become an environmental lawyer, having grown up in Charleston, West Virginia, a town dominated by the petrochemical industry. So I grew up amid a lot of pollution, which got me interested in the field. So I uh, entered law school in 75 to become an environmental lawyer. When I graduated, I went to work for a small environmental boutique in New York that no longer exists called Burley Cass and Case. In 1994, when it broke up, I moved laterally to the New York office of Arnold and Porter, where I became the managing partner. Practiced so in all, I practiced environmental law for 30 years, and wrote a bunch of books, including one on global climate change. And in 2009, I moved over to Columbia Law School to teach environmental law and the other subjects, and founded and direct the Sabin Center, which now has 16 full-time lawyers working on a whole variety of climate law issues at the international, federal, state, and local levels.
So when you first entered environmental law, it was a nascent field, air, water, waste, really the basics of pollution. Can you tell me a little bit about your transition from kind of traditional environmental law to climate change law? What led you to make that change?
Yeah, so throughout my 30 years in practice, most of my practice was on what you were talking about: air pollution, water pollution, contaminated sites, hazardous waste, a little bit of endangered species, a lot of development projects. And climate change law per se wasn't much of a practice area. And it's still a limited practice area in the United States for reasons we can talk about. But in the early 2000s, I began to see a lot more interest in the field. There were already some international agreements, and I started working on my book on climate change law in 2005. And that's really what got me much more interested and concerned about the issue. And I came to feel that I should try to find a way to devote myself full time to it. And so the Columbia opportunity presented itself, and that's what I've been doing since.
Let's let's talk a little bit more about that. The Sabin Center is, as I mentioned, the leading voice on climate change law and policy. Um, Tell me a little bit about what they do, and we can talk about some of their contributions to the field.
Thank you. So we track all of the climate litigation in the world. And when I get a chance, I'll put in the chat a link to our database, and also a link to where you can sign up for free updates, which we put out every month, soon to be twice a month. We also have something called the Renewable Energy Legal Defense Initiative, which helps arrange pro bono legal help to community groups and others that want wind and solar that are facing local opposition. We have a project that's about to grow considerably called Model Laws for Deep Decarbonization, drafting model laws at the mostly at the state and local level, uh, for how state legislatures and city councils and town boards can advance the needle, growing out of my book, Legal Pathways to Deep Decarbonization. We have a project on climate finance, tracking the disclosure rules and others. We have a project helping cities uh, work on their legal issues and track the IRA. So those are a few of the things that we do.
Um, can you tell me a little what model law project is kind of furthest along? I'm particularly curious about those.
We're doing a lot of work on electrification of buildings, on how building codes can be both more of the buildings can be more energy efficient, and how they can transition to electricity. We have a lot on electric vehicle charging stations, whether standalone or in buildings or parking garages or parking lots. We do a lot of work on the siting of renewable energy facilities, on zoning codes and building codes, to make it easier both to have rooftop solar and standalone solar and wind. Those are some of the things.
Hmm.
And
Um,
let me also mention that um, we use a lot of in pitching in, please contact me directly.
Well, I'm sure you will get takers on that from Morrison and Foerster and beyond. Let's kind of talk a little bit about climate change litigation in particular. And I do want to make sure that we drop the Sabin Center's 2024 retrospective in the chat somehow. Maybe I can figure out how to do that in a moment. Um, but just generally, given the kind of flurry of activity in the new administration, which we'll also dive into, how do you anticipate the climate change or climate litigation landscape shifting in 2025?
There will be a large amount of litigation challenging just about everything the Trump administration does. And this is the pattern we've gotten into during the Obama administration. Industry and the red states went to court to challenge everything they did. And then in Trump 1, blue states and environmental groups challenged everything they did. In Biden, we flip back and forth. But clearly the environmental legal community is mobilized to be challenging whatever the Trump administration does on climate change as soon as it becomes ripe.
And one of the things that's particularly unique about the Sabin Center is that it tracks U.S. and international climate change litigation. Do you foresee whether the international climate litigation response will kind of increase as a result of as the U.S.'s inaction?
There's been quite a growth in global climate litigation. Our database tracks so far we have about 2,500 cases globally. Of these, about 70% are in the US, but the number in other countries has been growing. Brazil has been a particular hotbed, but it's in other countries. And it's not so much in response to what the US is or isn't doing. Most of these are cases that are seeking to have their own governments take more action, which is really just about all that domestic courts can do anywhere. But as the climate conditions get worse and worse, and as governments globally continue to do too little, I think we'll see a steady growth of non-US climate litigation. And some of that has actually been more successful than some of the US litigation, which I can talk about if you want. But I certainly see a growth outside the US as well as within the US.
I'm curious about that. What type of litigation has been more successful?
So most countries in the world, but not the US, are signatories to a variety of human rights treaties. And most countries in the world, but not the US, have environmental provisions in their own constitutions. And so we see quite a few decisions in Europe, in Asia, in Latin America, a couple in Africa, in Oceania, where the plaintiffs are saying that the failure of the national government to do enough to reduce greenhouse gas emissions violates the international human rights treaties that these countries have signed on to and their national constitutions. Some of the decisions and several decisions have agreed with that. And several of the decisions have also said that the commitments that those countries made to the Paris Climate Agreement are legally binding on those countries. As a matter of international law, they're not enforceable. But a number of countries have said within those countries, they are enforceable. So we've seen a lot of decisions that have come out from all over the world, from other countries that seek to compel their national governments to do more on climate change.
Well, I guess we're in stark contrast here, given that we have a new administration that has actively withdrawn from the Paris Climate Treaty yet again, and maybe it's a good segue to talk a little bit about kind of the flurry of activity that we've seen. We're in the first 30 days. There's been innumerable executive orders. I think maybe for the non-lawyers on the call, and just to again set the stage. Can you tell us a little bit about how an executive order works, how it's different than a regulation?
So in theory, an executive order does not impose orders on the general public or on companies. It's telling the federal agencies what they need to do. Um, and generally, it doesn't have an immediate effect. The federal agencies then have to undergo a formal process in order to adopt or change regulations. Um, the executive order can be written with a stroke of a pen and withdrawn with the stroke of a pen. But in order for an agency to adopt regulations that are binding on the public and on corporations, it has to go through a fairly elaborate process called the notice and comment rulemaking process that takes months or years. So a lot of these executive orders have gone out. None of the formal rulemaking processes have really begun or will be finished for quite some time. However, they send very strong signals uh, to uh, to the government and the regulated community, and so people know what's coming, and these are already having an impact, even though the in final form that they're not out yet.
Yeah, and another thing that the Sabin Center has done is, and Michael in particular, has basically summarized briefly the executive orders that will have probably the largest impact on climate change, energy, and the environment. And that's another thing you can find at the Sabin Center as a resource. But let's talk about a couple of those and just get your views. Which ones do you think are likely to have the most impact in the short term on climate change and energy in the U.S.?
By the way, I just put in the chat a link to our climate database that has all these cases. Um, I think the freeze on Inflation Reduction Act money and Bipartisan Infrastructure Act money is having an immediate impact. We don't know how long it'll last because some of it, at least, is legally dubious, and there are a lot of lawsuits that are pending right now, some of which have led to temporary restraining orders. But basically, the signal that the president has sent out is that there's a freeze on this huge amount of money that the Inflation Reduction Act and the Bipartisan Infrastructure Act provided. And it's really cast a huge shadow of uncertainty over lots of industries. And particular relevance are the electric vehicle industry and the renewable energy industry. One order that does have immediate effect is no more leasing of offshore lands for offshore wind projects. And that has really cast a serious pall on the offshore wind industry. It's not clear to what extent they really have the authority to stop those projects that have received all their permits, but it's certainly creating a lot of uncertainty. So that's one kind of action that has had really an immediate impact. A lot of this will be sorted out in the courts in the weeks and months to come. The Biden administration tried to get out the door as much of the Inflation Reduction Act money as it could, but there's a question of how far out the door is it? You can have obligated funds, you can have contracts, but until it's actually in the bank account of the recipient, there's some question about that, and who knows whether they'll even try to claw some of that back.
Yeah, I mean, I think for most people watching this all unfold, there's this open question: like, can they do this, right? Will this breach contracts? Will this breach obligations, funds allocated by Congress? And I think we will have to watch to see when the temporary restraining orders and preliminary injunction hearings and such kind of unfold to see how that works.
One other thing to say about the Inflation Reduction Act is most of the money actually is not in loans or grants where cash goes from the federal government, but it's in tax credits. And the tax credits are written into the Internal Revenue Code. It took Congress to provide them, and it would take Congress to take them away. There are efforts to try to repeal the Inflation Reduction Act, including taking away the tax credits. I don't think that it will all be repealed, For one thing, most of the money is going to red districts, to districts represented by Republican members of the House of Representatives, and they're pushing back. In many of these districts, this Inflation Reduction Act money becomes a major job creator. There have been announcements of several multi-billion-dollar factories to make batteries and other things, which are creating a lot of jobs locally. And so I think the members of the House from those districts are going to push back against the repeal of that. So I think that's another fight that's going to play out in the Congress over the next several months. Meanwhile, the administration cannot unilaterally cancel the tax credits. It's possible that the Internal Revenue Service may make it more difficult to get them through the way it interprets various eligibility requirements and makes the claim forms available and so forth. But we'll see how aggressive the administration gets about trying to cancel that.
What do you think this this kind of ongoing uncertainty, do you think that'll have an impact on investment in projects going forward?
Oh, I think it already is. I think particularly in offshore wind, some projects that were just about ready to start construction, or maybe even that have started construction, I think some of the financial institutions are getting nervous. They're nervous about whether the tax credits that are underlying the economics of some of these projects are going to stick, or whether some other necessary permits are going to be granted. I think it's already having an effect on investments in this kind of activity.
And with this kind of uncertainty and with this basically the lack of kind of ability to understand where this is all going to go, how should companies and investors kind of adjust their strategies in the near term, if at all, when it comes to investing in climate and energy projects?
And I'll also mention I just put on a link to our climate litigation report. Previously I gave you the database, but here's the report. I think that companies need to be cautious. I think that what had been seen as certainty about the availability of these funds is now uncertain. And I think some of the permits that are necessary for renewable energy projects have been made uncertain. Clearly, new renewable projects on federal land or federal water, I think those are in peril. The Secretary of the Interior has issued a guidance on holding off on new permits for renewables in federal lands or federal waters. Beyond that, most wind and solar projects, certainly in the East, are on privately owned land and aren't subject to that. But we don't know what other obstacles they might try to throw up. Rooftop solar, that kind of thing, I don't think is affected at all in terms of permitting, but the tax credits for that are in some question.
And I just want to take this opportunity now. We're going to shift a little bit to regulatory rollbacks, but for those of you that are listening, if you have questions that you want us to pay attention to, you can put them in the Q&A, and we'll do our best to kind of work those in. The Trump administration has kind of made no secret that they are not in favor of any sort of climate change regulatory constraints, and that they, issued an executive order. There's a, national energy emergency declaration that is kind of out there saying to justify some of the deregulation. What type of regulations do you think are the most vulnerable to the EPA or other agencies trying to undo?
So the theme that we see throughout the executive orders on energy and environmental issues is to maximize both the demand for and the supply of fossil fuels.
Yeah.
And so the most important danger to the demand for oil is electric vehicles. And so there are a lot of efforts here to um, make it hard, take away the incentives for electric vehicles. There are also proposed regulations taking away or softening the appliance energy efficiency standards, since those have actually gone a long way to reduce the demand for electricity. They love artificial intelligence data centers, which are massively increasing the demand for electricity, but they want to take away the energy efficiency. Um, um, the so the EPA and Department of Transportation standards on greenhouse gas emissions and fuel economy for motor vehicles, I think, are likely to be weakened. There's also something called the California waiver, which
Yeah.
allows California to have stronger motor vehicle standards and actually drive toward electric vehicles. Um, I think they'll work on revoking that, and the California waiver under federal law other states can use the California standards if the waiver has been granted. And traditionally, states representing about 40% of the automobile market have signed on to the California standards. So if the California waiver is taken away, which I think the Trump administration will try to do, that'll have a big effect on the transition to electric vehicles. And, a lot of the automakers are already saying, look, this is giving us enormous uncertainty. We're investing a lot of money in electric vehicles and in making the batteries and so forth. That on top of the new tariffs that are being imposed on steel and aluminum, which is going to have a real problem for the auto industry in general. I think what we'll also see repeal of the regulations on emissions from coal-fired power plants. Today, the two largest sources of greenhouse gas emissions in the U.S. are motor vehicles and coal-fired power plants. And so the executive orders, confirm that that EPA is going to have to try to dial back on all of those. And I think we'll see these coal-fired power plants, most of which are really old or decades old, since nobody's building any recently, will continue in operation for a lot longer than they would have otherwise.
I mean, one of the things that's kind of underlying all of those emission regulations is the finding by the EPA in 2009 that carbon dioxide and greenhouse gases pose a danger to the public health and the environment, is the endangerment finding that was heavily litigated to the Supreme Court and back. One of the executive orders suggests that the administration wants to undo that. Do you think that endangerment finding is at risk?
Well, there are certainly some who are calling for it to be revoked, and I can understand why, because the endangerment finding is really the underpinning behind most EPA regulations on greenhouse gases. However, when the endangerment finding was first issued in 2009, there was a ton of evidence, scientific evidence that EPA had supporting the finding that greenhouse gases do pose an endangerment. As you said, it was heavily litigated. The DC Circuit ruled in 2010 that EPA had more than enough evidence scientific evidence to support it. If there was a ton of scientific evidence in 2010, there are now 10 tons. And so it'd be very, very difficult for EPA to make a decision that we no longer think it poses an endangerment, and for that to survive the inevitable lawsuits. What I'm hearing that there might be an effort to say is that the way the relevant sections of the Clean Air Act are written, or they say that the finding is whether these greenhouse gases cause or contribute to endangerment. And so there's some talk of arguing that U.S. emissions aren't enough of a contribution. But cumulatively, the U.S. is responsible for about 25% of the load of greenhouse gases that are in the atmosphere. Right now, our current emissions are about 15%, and China is about 25%, but we're still contributing a lot. So I think that trying to revoke the endangerment finding would really be an uphill battle, which is not to say that they won't attempt it.
That's, somewhat good to hear, right? It's simply because that is the basis for all kind of modern environmental regulation of greenhouse gases, as you said. Um, there's a lot of current environmental regulations that are being challenged in various ways. And I don't know, do you see the Trump administration kind of changing their approach to these regulatory challenges, or kind of refusing to defend the Biden era regulations?
Yeah, I think that's currently happened, and we're already seeing some of that happening. So, as I said, just about all the regulations that the Biden administration issued, environmental regulations, are being challenged in court. And I think the Department of Justice is now under order to ask the courts to hold off on the litigation while the EPA reconsiders the rule. Um, and the courts don't automatically have to do that, but they usually do. Um, and even if they require the litigation to go forward, DOJ is not going to give the same kind of defense to the rules that it would have before, and they may begin refusing to defend challenge regulations.
And I think one of the things we saw just this week, in the same vein, is that the acting chair of the SEC has requested that the court pause the appellate litigation surrounding the SEC's climate disclosure rule. This rule it took a long time to be promulgated and finalized, and then there was the expected litigation challenges. And now the rule itself is on hold. What do you see as the future for the SEC, or for, I guess, climate disclosure rules kind of generally, and in particular the SEC rule?
So the announcement yesterday from the new chair of the SEC that they're putting on hold, they're not going to defend the SEC rule that was challenged in court, was probably the least surprising event of the last week. It was pretty clear that the SEC was going to revoke the law, revoke the regulation. However, I think the action moves to California now, because California has adopted two laws on climate disclosure that will apply to every company that does business in California. And we don't know just how much business it has to be, but somebody did a calculation that something like 70% of the big companies in the US do enough business in California to be subject to those laws. Those laws actually go beyond what the SEC regulation would have done in two important respects. One, the California laws apply not only to publicly traded companies, but also to private companies, which are not within the jurisdiction of the SEC. So there are some very large private companies that do business in California that are subject to this rule, the largest being Cargill and Koch Industries. So that's one way in which the California laws go beyond the SEC regulation. The other one is that they cover not only scope 1 and 2, but also scope 3 emissions. As most people on the call know, scope 1 are the direct emissions from a company, its facilities, its vehicle fleets, and so forth. Scope 2 are the emissions basically from the generation of the electricity that it buys. Scope 3 is the supply chain, all upstream and downstream. So the original SEC regulation called for scope 3. That got a lot of resistance. The final SEC rule took out the scope 3 requirement, but the California laws do require scope 3. And an additional difference between the California laws and the SEC is that the SEC rule required materiality, that it only required the reporting of emissions that were material to the finances of the company. But the California laws do not have a materiality requirement. There were the U.S. Chamber of Commerce and some other industry associations brought a lawsuit challenging the California law. Just a couple of weeks ago, the federal court in California threw out two of the three claims in that lawsuit. The two claims that most people thought were the strongest, based on preemption and based on extraterritoriality. The district court dismissed those two claims. It left standing a First Amendment claim, a claim that the regulation involved forced speech in violation of the First Amendment. So that one is still pending. But in view of this decision, it is even more likely that the California laws are going to stand. I'm sure this will all be appealed to the Ninth Circuit, but they stand there. And so right now what's happening is the law gave the California Air Resources Board, CARB, the job of issuing the regulations, and there's currently an open comment period on what the regulations ought to look like. So those regulations will have a lot more detail on how big a company needs to be, what kind of disclosures need to be made, and so forth. So there's going to be a lot less attention to the SEC rule and more to California. Additionally, in Europe, there are important climate disclosure rules that apply to European companies, and including those that operate in the US and others. So the European rules also deserve attention by those who are thinking about what kind of climate disclosures they need to make.
Can you say a little bit more about the theories that are being used to challenge these laws, particularly the compelled commercial speech argument? Because I figure that any sort of disclosure requirement, whatever state enacts it, could be subject to the same types of challenge.
Right. I guess the idea is that if companies don't want to talk about climate change, they shouldn't be forced to. I think that's the underlying theory, but that theory would also, as you say, apply to a whole lot of other disclosure regulations that companies are subject to. And let me also mention that a bill similar to the California's law has been introduced in New York. I'm not sure if it'll be enacted, but it might be. So that would be an additional set of requirements that would apply to companies that operate in New York.
And I think the California approach has been a kind of a unique situation where they've noticed that the federal rule was at risk. They saw kind of inaction at the SEC level and decided to enact their own regime. I think New York, for example, also kind of taking unique approaches to figuring out how to battle climate change and running into litigation as well. Can you say anything? Can you talk a little bit about New York's climate superfund bill?
Yeah. So last year, Vermont enacted a climate superfund bill, and now New York has one. And what both of those say is that the fossil fuel companies that operate in those states need to pay a certain amount of money for. In the New York bill said they'd have to pay a certain amount of money to help New York State cope with climate change, adaptation, seawalls, and that kind of thing. So the New York statute says that any fossil fuel company that is responsible for more than 1 billion tons of greenhouse gas emissions, if they calculate how much oil and gas and coal it produced and we burn it, does it add up to more than 1 billion tons? And collectively, these companies need to pay $75 billion over 25 years. So it's basically $3 billion a year collectively. And so the state is going to come up with calculations for what share each of these companies has to pay. And there are various studies that have been done to show that, although I'm sure those will be contested. Um, so these payments have to start in a couple of years, and will help if it survives. Will help go through help New York prepare for climate change. Now, the Vermont law was challenged in federal court a few months ago, and just a couple of weeks ago, a lawsuit was brought in federal court in New York challenging the New York law. And the underlying theory, the most important underlying theory is that this isn't a job for the states. This is a national or international problem, and states shouldn't be imposing these kinds of rules. I don't know how that'll turn out. The lawsuit was just filed. There's also active talk now in California of adopting a similar law, especially in view of the Los Angeles area wildfires. Um, and a couple of other states are looking at it, but I think this is going to be a hotly litigated area for quite some time to come.
And I think one of the facts that this illustrates is that there are so many different types of climate change related litigation to watch, whether it's states challenging state laws or environmental advocacy groups challenging federal governments. There's going to be kind of litigation flowing in all directions, and the majority that we'll see in the short term, I think, is going to be with people challenging governments to undo what they are threatening to do or to comply with their own laws.
Let me just say the item that I just now put in the chat is if people want to sign up for the Sabin Center's free mailing list, which we put out, a monthly update on all the new climate litigation, but people can sign up through that link.
Yeah, and again, I highly recommend it because it covers I think 9 separate sub categories of the different types of climate litigation, whether it's environmental review for permitting, international, and the other types of litigation that businesses face. I want to talk a little bit about the litigation that might be threatening companies, and I think there's kind of 2 main categories that we think of when we think of kind of climate disclosure litigation, one being kind of shareholder activism and the other being consumer claims. Can you talk a little bit about the shareholder claims in the climate space and what you've seen as the trend?
Yeah, those haven't gone so well for the plaintiffs. There have been a few attempts, but the principal impediment there is loss causation. Is the plaintiffs would need to prove that the company, its directors breached their fiduciary duties and not adequately preparing for climate change or something of that sort. And nobody has really been able to prove that. A lot of the risks that are pointed to are future risks that haven't yet been realized. For instance, that the coal industry or the oil or gas industry would be greatly shrunk as a result. So those cases have none of them have succeeded. There haven't been many of them, I think partly because plaintiffs' lawyers know that they're not likely to succeed. So far, in the U.S., there haven't been, to my knowledge, any lawsuits against individual officers or directors concerning climate change. And there have been a little bit against companies, but they haven't gotten very far. The closest, the one that got the furthest was a lawsuit that the state of New York brought against Exxon, saying that its climate disclosures were misleading and were a violation of the Martin Act, which is New York's blue sky law, New York's securities regulation. That went to trial, and Exxon won. The court found that New York State had not shown that Exxon had been misleading in its statements to its shareholders.
Yeah, I think that, as we know, plaintiffs generally keep trying, and till they find a theory that works. I know there's been claims in the consumer space as well. Basically, when a company advertises their product or service or their offerings as carbon neutral or net zero or otherwise climate friendly, and then they claim that those representations are not substantiated, they file consumer claims or consumer class actions. Have those experienced any success?
Um, Not in the U.S. And it's the main problem with that again is similar to loss causation. That people have not been able to establish that they were actually harmed by misleading statements. I think it's pretty clear that there has been a fair amount of greenwashing by some companies, companies overstating what they're doing to reduce their greenhouse gas footprint. But consumers haven't been able to demonstrate that they were actually personally misled and lost money as a result of that. Just a couple of weeks ago, one of those cases brought by New York City was dismissed, where the city had brought a suit against several oil companies saying that the oil companies had violated the city's consumer protection law, but the court found that the city wasn't able to show that the consumers had actually been misled to any real degree. There have been similar results to some suits against the airlines. Now, there both the UK and Australia have sort of advertising review boards that have found a lot of companies to have engaged in greenwashing. And there were quite a few findings there. In the US, the Federal Trade Commission would have the authority to do that. It's done a little bit of it, but not very much. And I assume that in the next 4 years, they probably won't do any. So these consumer misleading claims have not gotten very far. Part of it is, okay, the oil companies didn't reveal that if you burn their gasoline, it'll cause greenhouse gas emissions. But even if they had, would that have an effect on driving behavior? Would more people have switched to subways or bicycles? It's really hard to prove that the lack of that information had had a large effect on consumer behavior.
Right. I mean, I think probably the most, well-known kind of claims against particular companies and fossil fuel companies are the claims brought by state attorneys general, and those have been going on for some time in various states. Can you give us an update about what those claims are and where they stand?
Yes, I mean this round of litigation began back in 2004 when New York State sued American Electric Power and some other power companies for an injunction to reduce the emissions from their coal plants. And that was seeking an injunction using a public nuisance theory. That went up to the U.S. Supreme Court and said, no, that's displaced by the Clean Air Act. Then there was a similar case pending brought by the village of Kivalina, Alaska, against Exxon, seeking not an injunction, but money to relocate their peninsula to a safer place. And that was then dismissed. But the Supreme Court left open the question of saying you couldn't use the federal common law, but maybe you could, but they left open the question of whether these could proceed under state common law. So starting in 2017, we saw a whole bunch of lawsuits brought mostly by states and cities and counties under state common law. There was then about a decade of litigation about whether these cases belong in federal court or state court. They ended up in state court. But the one that had gotten particularly far along was brought by the city and county of Honolulu. The state Supreme Court ruled that the case could proceed. The oil companies and a lot of others tried to get the U.S. Supreme Court to take that case. The Supreme Court refused to take that case. I understand that just yesterday, the oil companies filed a motion for summary judgment to try to get rid of the case on statute of limitations grounds. So that'll proceed for a while and will probably have to be decided before that case proceeds to discovery and then to trial. The case in Massachusetts, which is all about consumer fraud, is further along. It survived an appeal to the state Supreme Court and is now in discovery. It may go to trial. We've also seen in the last couple of months several of these cases dismissed at the trial level. And so a case brought by Anne Arundel County, Maryland, and a couple of other cases have been dismissed at the trial level on legal grounds. Those are all going to be appealed within the state court system. So the bottom line is there are a lot of these cases that they're pending. They're being very vigorously and effectively defended so far. We don't know if any of them are actually going to get to trial, but I think these cases are going to be with us for quite some time, and they do get a lot of attention. And in addition to the legal efforts, they also are part of an overall campaign.
I would love to delve into the specifics of those claims, in particular whether public nuisance you think is a viable legal theory, though, a theory for redress of climate-related harms. But I'm getting an indication I should ask the kind of wrap-up questions. And you know, given the breadth of climate change-related litigation, and where it's coming kind of from all directions. Um, you know, do you have any general advice for companies to mitigate their climate-related litigation risk? I know it's a broad question, but I thought I'd give it a shot.
I think the greatest climate change related litigation risk stems from misleading statements. Um, Things like net zero pledges. California also has a law on trying to regulate the voluntary offset market. So we see a lot of companies that said we're going to get to net zero by 2050, but not or whenever, and not saying how. And I think that because of the legal risk, a lot of companies are now backing off from those statements. So I think the most important thing is whatever you claim and whatever you promise, you need to be able to back it up. Because if you can't do that, I think there are a number of theories that could create liability. We do not yet have any decisions anywhere in the world in which a court has imposed financial liability on a company for its greenhouse gas emissions. There are a couple of pending cases in Europe that are trying to do that may get there, but we haven't had that anywhere. And so as long as companies are meeting the other legal requirements or acting within their permits and so forth, there hasn't been that kind of financial exposure yet.
Makes sense. I mean, it certainly is going to be something to watch as this unfolds, in particular the cases against the oil companies. If they're able to recover something financially, I feel like that will produce significantly more litigation, not just against oil companies, but against others.
Right.
Well, this has been tremendously informative and helpful. I think we've covered a broad variety of topics. I saw a couple of questions in the chat from the audience that I think we had a chance to address. And with that, I think I will pass it back to Aaron.
Thank you, Michael. Thank you, Bill. That was really, really valuable, really, really interesting. And Michael, I really appreciate your careful analysis and with a lot of very, very important detail. And I suspect this is a fluid situation that will be developing. And Bill, thank you so much for eliciting some really great content that I'm sure everyone on this Zoom call will value. We will be back with another episode in March. So stay tuned. Look for an announcement coming soon on our next episode. It'll be at the end of March, so a little more than a month's time. And we, like all of you, will be watching and for all of the many changes and developments that are coming. I will end with one editorial comment, which is from Andrew Steer, who just announced his departure from the Bezos Earth Fund, who said late last year, elections change a lot of things, but they do not change physics. And so the impacts of climate will continue to be felt. And we hope that we will have legal litigation, public policy, and capital market contexts and rules that will enable and not interfere with action. That is in the interest of all of us and in the interest of every company. So if you don't mind a little bit of editorial comment, I want to add that in at the end. But let's just close by saying thank you very much for joining us. We hope you'll be with us again next month. Bye now.
Thank you.
Thank you. Bye.